All right, good afternoon, everyone. And I think that we had some interesting information and that will continue with this section, which is with power comes great responsibility as we talk about contempt, the powers that a judge uses to try to get some compliance. And we know for those of us, I see a new judge that's over at the municipal court that was with us for many years over at the Court of Appeal, that we know sometimes we can get it by just a look, a gesture, a question. Oh, I know we're not going there. But when that doesn't work, you have to utilize other tools in the toolbox. So we will talk about that. And we have a very distinguished panel. The Court of Appeals has a great brain trust that we are able to draw from as we try to make sure that we give accurate information in our opinions. So I'd like to first introduce Jake Dicus. And Jake has been recently appointed as Assistant Court Administrator, our Chief Legal Counsel. Now, Jake didn't have a fun fact in his bio, but I know he likes to cook because when we have our potlucks, he's always giving us some interesting dish that he has prepared. Next, we have Darcy Del Sordo. She's been with the court for 20 years. And her interesting fact, and I'm sure she's thinking about it right now, she likes to visit beaches across the world. And finally, we have Robert McKillop, who is an assistant public defender. He has a great background, but he has chosen to work with the public defender's office, and we appreciate that dedication. His interesting fact is he competes competitively as a fencer. So with no further ado, we will present the panel and here's some great information. Thank you.
Our presentation is about contempt. With great power comes great responsibility. I'm going to talk about some of the background and of contempt. Rob's going to talk about some of the due process of zones and everything. Darcy's going to talk about some practice tips. So first, we have the different types of contempt. You can break it down into 4 categories: criminal versus civil, direct versus indirect. Rob's going to talk more about direct versus indirect, so I'm going to just go over some of the civil versus criminal sections. It's basically based on the sanction that's going to be imposed. Civil is remedial or coercive in nature for the benefit of the complainant. There's usually a condition that you can purge the contempt, so you can relieve yourself of whatever sanction is going to be imposed or is imposed. Whereas criminal is to vindicate the authority of the court or to enforce an order. There's also a different evidentiary standards that apply. In civil, we're looking at a clear and convincing evidentiary standard. In criminal, must be beyond a reasonable doubt. There are various sources of authority for contempt. In the federal courts, the U.S. Supreme Court has said that courts have inherent authority to regulate proceedings and enforce compliance with its orders. The Judiciary Act of 1789 that established the lower federal courts also included a contempt provision in there for authority to punish all acts of contempt. That was later codified in 1831 into 18 U.S.C. 401. It's remained largely unchanged. Where the changes occurred is in case law and in the federal rules. Federal Criminal Rule 42 provides for notice and opportunity to be heard in a jury trial. However, for direct acts of contempt, the jury trial is there's an exception there. There's an interesting historical analysis of the evolution of contempt powers that's available on the Judicial Center, the Federal Judicial Center's website, jfc.gov, and there's a permalink, which we talked about earlier, there in your materials, so you can use that and go find that paper. For state court powers, the Ohio Supreme Court has also held that courts have the inherent authority to regulate proceedings and ensure compliance with their orders. There's also a statutory scheme for contempt. RC 270501 basically defines acts of direct contempt, those that occur in the presence of the court and obstruct the administration of justice. And then RT 270502 basically is all other acts of contempt defined as indirect contempt. And there's a non-exhaustive list in there as well. Magistrates also have the authority to impose sanctions for contempt. Federal magistrates, they can impose up to a Class C misdemeanor, basically. Anything beyond that has to be referred to the judge. That's 28 USC section 636E. Civil Rule 53 and Juvenile Rule 40 also give magistrates the ability to impose sanctions for acts of contempt committed in the presence of the magistrate. That sounds a lot like direct contempt to me, but there's some questions about that. There's also a provision in those civil rules and juvenile rules for review of the contempt finding by the judge. Punishment is determined by the statute RC 270505. For a first offense, a fine is not more than $250, 30 days in jail. Second offense, $500, 60 days in jail. Third offense, $1,000, 90 days in jail. However, there's some tension between the authority of the legislature and courts. Courts have held that they have inherent authority to impose whatever sanction they deem necessary. And I'm going to talk a little bit about sealing here because there's a couple of recent Supreme Court cases that I would argue that a court does not have inherent authority to go beyond the statute. One of those cases specifically is State versus GK. In that case, there were very serious charges brought against an individual, rape, kidnapping, GSI, and along with an obstruction charge. As the case went on, it became apparent that the defendant didn't commit the acts of rape as part of a plea agreement. The defendant pled guilty just the obstruction charge, and the other charges were nullified or dismissed. And because the person was not eligible for sealing at the time for that conviction, he brought a motion with the trial court to seal the records of the dismissed charges, those three charges which are impacting his ability to do things like find a job, that sort of thing. The trial court, citing to its own inherent authority to seal records, which is a power that's, goes back probably just as far as contempt, said, okay, we're going to seal just those dismissed charges while leaving the conviction in place. The state appealed, and the Ohio Supreme Court said, no, you do not have inherent authority to do something when there's a legislative scheme in place that you could not do under the legislative scheme. So I would argue that there's a legislative scheme in place for contempt, and the trial judge does not have authority to vary the sentence that has been decided by the legislature. But nobody's made that argument yet, so we'll see how it goes. There's also an exception to that, the punishment. RC 270506 does allow for an indefinite jail term. But there are limitations. Does not apply to past contemptuous acts. It is used to coerce some sort of action, and the contemptor must have the ability to perform the action. Classic example of this, I think, is a journalist who refuses to reveal their sources after they're ordered to by a judge, and the judge places them in jail until they reveal their sources. Another exception is a debtor's prison. Contempt cannot be used as a de facto debtor's prison. Contrary to what some judges and this judge here in this case, court costs are just like any other civil judgment. You cannot use contempt powers to put someone in jail for failure to pay court costs. They're a civil judgment. It must be collected like any other civil judgment, and that does not include jail. I'll turn it over to Rob. Yeah.
All right. Hi. So, there, like many of the other things we've heard about today, that it seems like every court likes to kind of do its own little definition. So there are a bunch of quote theory. We'll get the written materials. I think probably the best and most comprehensive definition of contempt generally is the middle one in the blue area on the slide, which is conduct which brings the administration of justice into disrespect, or which tends to embarrass which I don't know exactly what that means, but or more importantly, and more commonly, impede or obstruct a court in the performance of its functions. So for direct contempt, the basic definition is that latter part of that larger definition, interfering with an active court proceeding or hearing or whatever. The generally speaking, the conduct that constitutes the contemptuous act must occur before, like, actually physically before the judge or other court personnel, which can include the court bailiffs. There is some suggestion it includes court reporters. The Ohio Supreme Court hasn't said that, but a number of district courts have. Certainly, it includes. There's pretty much no question that it includes the bailiff, and obviously it includes the judge. It also includes conduct that is so near to the court that it is like constructively in the court's presence. Commonly, what you see in the cases is like when there's a melee in the hallway. So like in the Court of Common Pleas, there's two doors, and one of them has no windows. So it's not actually like literally in the court's presence. But if people are screaming and fighting and banging things in the hallway, that very well may like disrupt and I guess potentially even embarrass the court and obstruct its functioning. And so that would count as direct contempt. That sort of thing is less common than like outbursts in the courtroom or things like that, where it is in fact right in front of the judge. We have a question? Yes.
Yeah, when it's defining the court, and you say it includes the bailiff and the judge, does that include the jury?
Well, yes, it does, and that's actually this next slide. So something weird.
Exciting.
Yeah. So usually, and I'll talk more about the due process or what process is due for direct contempt, but the answer, a little spoiler, is not much at all. The exception is in the rare, extremely rare situation where the contemptible or contemptuous act occurs in the presence of the jury. And so that happened in at least one case, State versus TF, where it's actually wonderful. One of the jurors during jury deliberation just brought a bunch of newspapers with stories about the case into the jury room, just handing them out and wanting to report that discussion about it. Just totally lawless. I don't know what this guy was thinking, but he got in trouble and was held in contempt and was held in direct contempt. And again, as I mentioned, and we'll discuss in a couple slides, direct contempt, there's extremely limited process that's required, and certainly what is not required is like an evidentiary hearing or an adversarial hearing or anything like that, except in this context, and potentially context of like a fracas in the hallway or something like that. That's only the constructive presence of the court. There, a hearing is still required. So it counts as direct contempt, even though it's not in the physical presence of the court, but merely the constructive presence. But unlike if there is just an outburst in front of the judge, or as sometimes happens, directed at the judge, unlike in that situation where a hearing is not required, when the court personnel is the fact finder in the guidance of the jury, then a hearing is, but that still counts as direct contempt. So I mentioned that very little process is required, and that's true. I mean, some of the cases say that there is no due process is required. I don't really think that that's accurate. I mean, you always have due process rights. Just the process that's due in this context is de minimis. Essentially, what it requires is that the trial court enters a judgment that has a combined finding of fact and conclusion of law or judgment that a contemptuous act occurred and the person did it, and that is it. So that's really not very much, but it's still not none. I mean, the court still has to find and note the facts. But beyond that, procedural due process rights are essentially inapplicable. I mean, you don't have a right to counsel, you don't have a right to allocute or really say anything in your defense. And if you have an outburst in court, you can simply be placed in jail, right? And that's it. It just happens summarily, as long, and it is lawful to do that, as long as that fact finding makes its way into some journal entry. And that State versus Pryor case, was me. I lost it. It's me who is the content. But yeah, okay. Sanctions. So Jay talked a little bit about sanctions. There is, there's an open question most of the time, though. I think part of the reason why the case law in this area is limited is it really is rare that you see kind of capricious punishments here. I mean, it does. I'm going to throw you in jail for 4 hours because you said a bad word to me, the judge. You know, so it's rare that someone is thrown into jail beyond the maximum that's established in Chapter 2705, or where a fine is imposed that is beyond the fee schedule or the fine schedule established also in Chapter 2705. There may be an appeal issue there. Certainly, if you're doing an appeal of a direct contempt, you should make sure that that fact finding has occurred and that it's present in the journal entry. There may also be a question, I mean, it's kind of up to you about how much you want to push, like what the boundaries of what the clear law is, how much you want to push the boundaries, but there may be a challenge to the reasonableness of the sanction, particularly if it deviates from those standards that may or may not apply, and kind of cover the field as set out in Chapter 2705. And then probably most important thing is to make sure that the contemptuous conduct that the person was found to have engaged in was in fact direct contempt. Which again, usually means that it occurred in the presence of the court. In the case of indirect contempt, you do have close to ordinary procedural due process, right? So certainly you have the right to a hearing on the charge. You have the right to assist counsel, to offer testimony or subpoena people to testify. You have a far broader set of protections as the contemptor. What indirect contempt is interfering with the court's processes outside of the court's presence. Usually this is things like not responding to discovery requests, ignoring or failing to comply with orders of the court that are issued through journal entries. So like not really to you in the presence of the court. If the court tells you to do something during trial and you simply don't do it, that is likely to be direct contempt. But if a journal entry is issued saying turn over this, or send that, or whatever, and you don't do it, that may be indirect contempt. Again, you still have to actually disrupt the court process. So kind of merely not complying to the satisfaction of the court may not in fact be any kind of contempt. But the important and the major distinction is that you have the right to a hearing. One of the most common things in the cases is lateness of like a person's physical appearance at a hearing. The attorney will be told to show up to a pretrial conference at noon, and maybe doesn't show up at all, or shows up at 3, and then is held in that is a situation where a person would appropriately be held in indirect contempt. Often what you see is that they are held in direct contempt because the court thinks, well, here I am, the guy's not here. That's happening in my presence, like I am here alone without this attorney. But in fact, that is indirect contempt, and the cases are very clear about that because the lateness is occurring outside, like by definition, your lack of presence is occurring outside of the presence of the court. Otherwise, whatever you were doing would not be lack of presence. So bear that in mind when looking at things, because one of the rights that you have in that hearing where you can allocute is especially in like lateness or non-appearance situations, but also with missing filing deadlines, especially discovery, especially as I gather, I've done civil law for many years, but discovery issues in civil law especially, you have the right to explain why that happened, right? So there's a big difference between not showing up to a hearing at noon because like you just didn't feel like it. Noon's not a good time. You know, it was unfair to set a hearing at noon. That you can't do. Not showing up at noon because you were hit by a bus is a pretty good reason. So the judge might be furious until you allocute and then explain, well, you're like in a full body cast and explain, here's why I was not at that hearing, or here's why I didn't send that discovery over, right? So there are, that requirement for a hearing is the major and important distinction. I already said all of this, I think. So yeah, there's a little less discretion in terms of how the issue can be handled between indirect and direct contempt. With direct contempt, you can be essentially summarily punished. The punishments are comparatively mild, but nonetheless, it's a pretty quick process. Most of this is explained in chapter 2705. As Jake noted, I didn't leave enough time for Darcy, so.
Good afternoon. Jake and Rob have given you all everything you need to know about contempt, right? So I get to do the fun part. If anyone has, or get out your pen and paper because it's time for a pop quiz. Actually, just kidding. The fun part that we get to do today is what to do if your client has been held in contempt. We're going to talk about some practice tips. Overview of what to do. There are 3 things you need to know. 1 is a direct appeal. 2 is an original action in the appellate court, otherwise known as a writ. The 3rd thing we're going to look at today is a stay of execution of judgment, which is particularly important. As the gentleman we're discussing, if your client is incarcerated, the stay is really important. If it's a money sanction, there's other ways to attack that. You can do a stay, of course, but we'll leave it at that. So the first thing we're going to talk about, the first option you want to look at is a direct appeal of the contempt order. The first thing you need, of course, is a final appealable order. Definition for that, as related to contempt, can be found in the statute that you see on the slide. In general, that journal entry needs to have the finding of contempt, and it also needs to have the sanction or the penalty that was imposed. Those 2 things need to be done by the trial court before you can file an appeal. A situation that we often run into that talks about final appealable orders and contempt has to do with magistrates. Magistrates have the power to hold people in direct contempt. As many of you know, magistrates' orders are not final and appealable. So what do you do there? There's a couple different avenues you can take. You can refer to Civil Rule 53, Juvenile Rule 40. They both cover magistrate orders. One thing you can do is file objections to those magistrate orders. If a trial court timely rules on that, your order can become final, appealable, and then you can go on and file your appeal for contempt. If you file objections to a magistrate's order and you're getting no satisfaction from a trial court, you can file a motion to rule on the objections or rule on the magistrate's order, push things along. Again, I can't guarantee you success, of course, but it's a best practice type of tip to do. What we're looking for again here is a final appealable order. One thing that we kind of stumbled across when we were doing the research here is a potential challenge. If you have a magistrate's order and you're not doing the things that we just discussed, can you appeal it? Can you go under the statute 250502 and go through the regular test for a final appealable order? It's a challenge that we don't know has been made. We didn't run across one. So if anyone's up for it, that be an interesting project. Just don't hold us to anything over here. So the next thing you want to do there now, you want to file your notice of appeal. After you file your notice of appeal in the appellate court, you immediately want to move for a stay. You'll find that under App Rule 7, application for a stay must be filed initially in the trial court. There are very few exceptions to this. Best practice is to file it in that trial court. If the judge grants the stay, you're in business and you can move forward with your appeal. Again, this becomes more important with incarceration, but if the trial court denies your request for a stay, a second step would be to file that same request for a stay in the appellate court. Earlier, I believe it was the first set of speakers, talked about persuasive opportunities. And I think that comes into play here. If you're going to file motion for stay in the appellate court, include everything, attach everything to that motion that you think the court would need to grant the stay, to rule in your favor. Example would be journal entries and motions, some things like motions to compel, rulings on motions to compel, motions to show cause, rulings on that. Obviously, the contempt proceeding itself, if it was done in open court, there's a little known rule called App Rule 10F. It allows you to order or request, a partial transcript from the Court of Courts. In it, you would have that sent up to the appellate court with your motion for stay. You're arming the folks over that, the appellate court, the judges and the staff, to rule in your favor there. If this did not happen in open court, the transcript is not available. There's another rule, App Rule 15A, that allows you to attach certain documents to motions. What we're envisioning here would be an affidavit, would be a good example. My client was held in contempt, there's no transcript, but here's my rendition, my client's rendition of what went on. That would be helpful for the appellate court. Next. If you can't file an appeal, if these things that we talked about don't work, you don't have a final appealable order, you can file an original action in the appellate court. Those are otherwise known as writs. Typically, we're looking at a writ of habeas corpus. One example, I suppose, of when you would use this, there's no final appealable order. That would be an example of when you could file a writ. An example would be a magistrate's decision that you just can't get satisfaction on, and you don't feel like taking us up on our challenge to see if that's final. You would be able to file a writ of habeas corpus. What about if a court holds you in contempt, but they don't journalize it? They don't follow through with the journal entry. That's another example of when you can have a writ of habeas corpus. I don't pretend to be an expert on writs, but I did put the statute on the slide. Did I not? Sorry about that. There is a statute up there. It's actually pretty easy. The biggest thing I got out of it, when you're filing that writ of habeas corpus, you want to attach the commitment papers. The commitment papers usually consist of the journal entry, holding the client in contempt. Again, it has that penalty and that sanction there. You can use an affidavit, would substitute for commitment papers if you don't have that journal entry. There we are. No. Okay. There we go. What is a writ? Or I'm sorry, writ of habeas corpus. Who do you file that against? You typically are going to file that against the person that has custody of your client if your client is incarcerated. A sheriff, a warden, a jail official would be the usual party to that. Can you file a writ of habeas corpus against a trial judge or a magistrate? Typically, the answer is no there. Those are usually done through writs of mandamus. There are a couple cases out there that have filed a habeas action and a mandamus action together regarding contempt. The reason that someone would do that, when you're talking about a writ of habeas corpus, you don't really enable an appellate court to get a trial judge or magistrate to do anything. You're enabling us to get a sheriff or warden to do something. With a writ of mandamus, we can look at ordering a trial court to do something. Those would have to be filed simultaneously. That's just the difference there between the writ of habeas and the writ of mandamus. Last option we have is seeking an alternative writ. It's local App Rule 45D2. In a nutshell, this is used when you need an expedited disposition. The form of the writ is all in the rules. It must be in a separate application, and it just allows us to rule in a more speedy manner. this whole end of the portion really has been about best practices and tips, but just the last thing I want to leave you with here is if you do have a client in contempt and you're taking one of these actions, you can always call the Court of Appeals. The 8th District number is back up there behind me. Ask to speak to a staff attorney. Let them know what you're filing and when you're filing it. It will help us get staff ready, prepared for it. A lot of these things can involve emergencies if you want to keep your client out of jail. So it helps to give us a heads up so that we're prepared to rule on it. I think that wraps up our presentation on contempt. Thank you.